Hello everyone, welcome to today's webinar. My name's Connor Spencer. We're going to be discussing hiring your first employee, get it right from the start. We've done a similar webinar to this before, as like employment law and workplace policies is a very hot topic here at Lawpath. So people who do come to us for the first time or even current subscribers, often coming to us for an employment related issue. Where they're just getting some information or maybe something's happened in the workplace that they need resolved. And as you guys will know, we're using the platform. We provide year-round support, providing the contracts themselves, the workplace policy, the employee handbook, but we also provide our clients with advice directly from our lawyers. We'll go into more detail shortly. I'll cover a little bit about Lawpath, obviously who we are, how we can directly assist. We do have some updates and changes as well, which I'll address probably closer to the end of the webinar. I'll introduce Damin as always, who will be discussing today's topics. Damin will be covering for us understanding the most recent changes and updates in employment regulations. We'll be going through best practices for drafting and updating your employment agreements and policies, tips for avoiding common legal pitfalls and minimizing the risk of litigation. And finally, navigating wage and hour laws, including minimum wage, overtime, and leave laws. And what I'll do now, actually, for anyone who might be interested, obviously today's largely going to be around employment, but if you want to see some of the other hot topics we cover, as always, I'll just include a link there where you can see some of the most common topics we're addressed on, whether from a legal or accounting perspective. You can also see our reviews and video testimonials from clients. There's a link there as well in the chat to our current internal lawyers, which you can book in through with our legal advice plan. And I've also included a link there to our YouTube page to a webinar we did Tuesday, where I went through a bit of a live demo of the platform. We had a mix of free accounts and subscribers. So if you actually would like to check that out, whether you're brand new to us or actually subscribe to us, you might find the content there actually really useful to have a bit of a rehash of some of the tools and features available to you, especially if you've been with us for a year plus. We've had a few updates within that time frame. Might be good just to check that out. So finally, we'll conclude with a Q&A session. You'll be able to submit your questions in the Q&A chat box. It is a separate button from the general chat. I mean, we do check both, but it makes life easier if it's all in the Q&A. So if you do have any specific questions to the topic, add them in there and we will address them at the end. So if you are discovering us for the first time, if you're new to Lawpath, we're an Australian-based online digital legal platform. We've been operating for about 10 years now. We've helped over 500,000 small to medium businesses in different capacities within that time frame. So we're very much tailor-made for startups who need that service to fill in their gaps in legal knowledge, and obviously do it in a way which keeps the startup costs down to an absolute minimum. And we've done this in a myriad of ways. So we provide on-demand legal assistance through the software and our contract management system, as well as same-day or next working day professional legal and accounting advice and tax compliance advice through our consultations portal. So we now actually have over 500 legal documents in our library. These are all up to date with Australian legislation. They have all been drafted by lawyers. In fact, a lot of our documents are provided by our partnership with LexisNexis, actually one of the largest legal suppliers of documents and legal material to lawyers. I think, correct me if I'm wrong, Damin, but I think they bill around 10K a year for that service to lawyers. So we're very tailor-made, as I said, for startups by comparison. Our essentials plan, for example, is just 468. And if you do want that added peace of mind, you can always get our legal advice plan or upgrade to our legal advice plan, which still includes the documents, but now you get the added benefit of unlimited consultations to discuss perhaps your employment issue or any other commercial legal matter, as well as getting those unlimited on-call contract reviews of our lawyers. So today's webinar is, of course, joined by Damin Murdock. He is Lawpath's principal lawyer. He has been practicing for decades and has extensive experience within this particular field, as well as many other legal areas in commercial and business law. Actually, Andrew was telling me yesterday, Damon, that you know it all. So if anyone wants to view the lawyers page, again, that's including the link there. You'll see our lawyers there, including Damon, who actually has a 5 out of 5 star rating out of over 300 reviews, which is fantastic. So that's enough from me. I'll hand things over to you, Damon.
Great, thank you very much. Hello, everybody. So we love answering your questions. So if you have any questions, put them into the Q&A box. It's always the most valuable time to go over your questions. Your questions are probably very similar to what other people have. So you normally will get a lot of value out of that. So what we're going to do is we're just going to start off very simple, and then we're going to slowly get into more complex things. So at the very beginning, talk about an employment contract. Now, I have a lot of clients that say, well, my staff are on a modern award, and they're hired as a casual, so I don't give them an employment contract because all the governing terms are set out in the modern award. And that's true in terms of how much you pay them, but it's not true in terms of what their job responsibilities are, intellectual property, confidentiality, non-solicitation of clients, taking away your um, confidential information, but more importantly, binding them to company policies, things like that. So an employment contract, whether it's a casual, part-time, permanent, fixed, it's always important to have because there's certain obligations that you really want in a contract that go far beyond what's just in a modern award, for instance. And if you don't know what a modern award is, that's okay. I'll explain that as well in the coming slides. So certain things that you want to put into an employment contract, it really does vary depending on your industry. It depends on the seniority of your staff as well. So if you look at your existing employment contract, there's normally 2 ways for a termination clause to apply. That is that both the employee and the employer must give a fixed period of time to terminate the contract. So normally that might be about 4 weeks. But sometimes people just say in accordance with Section 117 of the Fair Work Act. And there's a table, and sometimes you actually have that table in your employment contract itself. It says if you're employed for less than 1 year, then both parties only have to give 1 week notice. If you're employed for 1 to 2 years, 2 weeks notice. If you're employed for 2 to 3 weeks notice, and it's so on. And it's a sliding scale. The longer someone's employed, the longer they need to give notice. Now, the main issue people normally have is if they have that clause that just simply says you have to give 4 weeks notice and we have to give 4 weeks notice to terminate your employment, then you could hire someone that's just simply no good. You want to terminate them after 3 weeks of working for you, and now you're stuck paying 4 weeks notice to them. So we normally have a probation clause in the employment contracts, and it says that if you've been employed for a period of 6 months or less, then the notice period is 1 week. And if you've been employed for more than 6 months and then for 1 year, then it's or more than 6 months, then it's a lump sum 4-week period. It really does depend on your industry, but you don't want to be stuck paying somebody 4 weeks notice if they've only been employed with you for a couple weeks. Now, the other thing is leave entitlements. Leave entitlements is mandatory. It's statutory. You can't contract out of it. So you don't necessarily need to have an employment contract that sets out their long service leave, annual leave, public holiday pay, sick leave. That's automatic. So if you do have a template that includes it all, great. If you don't include it, it just automatically applies. A non-solicitation clause, that is basically saying the employee that's going to be working your business is going to know your suppliers. They're going to know your customers. They're going to know your prices. They're going to know everything about your business inside out. And you don't want them to go learn how you operate your business and go start up a competitive business. Now, a non-solicitation clause doesn't stop someone from starting a competitive business, but what it does is it stops them from taking your employees away, taking your suppliers away, taking your clients away, and then servicing them in their new business and resulting in these people all leaving your business. So that clause is really important. It's not not a restraint of trade. It's not stopping someone from starting a competitive business, but it stops them from stealing your customers. And that normally is really valuable for anyone that's been in your business for quite a while. And even if you hire someone that's fairly junior now, it might be a case in 5 years from now, they're senior. And if you don't put a non-solicitation clause in the initial contract, it's going to be very difficult for you to ever get one into a future contract because there's no obligation on an employee to sign a new contract on new terms. Now, the job title and description is also important. The reason primarily that becomes important is because if you need to change their roles and responsibilities, then it becomes something that potentially could be constructive dismissal. By changing someone's job description or title without their consent, that could be deemed as a termination by the employer, and it could warrant an unfair dismissal claim. So what you want to do is you want to put in the job title, you want to put the description in, but you want to make the description fairly broad so that you can capture additional duties within that broad description. So normally at the end, it's general administrative duties, other duties that are assigned to you reasonably, things like that. And that's really important as well. Obviously, you have commencement date. We talked about the termination provisions, remuneration that is always in an employment contract. Now, sometimes you might hire someone under a modern award. And in those circumstances, you don't need to put the actual hourly rate. You can just say you were hired as a level 1 blah or level 1 clerk under the clerk's award. And you don't need to put the hourly rate because the hourly rate changes on the 1st of July every year. But if it's anything else where it's an annual salary, you need to put the remuneration in. Employment status, whether they're fixed fee, part-time, permanent. And we'll talk about fixed term employees in a couple slides from now. Confidentiality, what is important is that if you ever hire a contractor, and whether you hire an employee, there's different rules that apply. So for instance, if a contractor is hired to do work for you, that contractor automatically owns all the intellectual property that they create. And they generally would give you a license to use it because you're paying them a fee to do some work, but they own the intellectual property rights. Whereas an employee who does work in your business, all the IP that's created in their roles and responsibilities when they're delivering them is owned by the company. So if you ever do hire a contractor, you must have a confidentiality clause and you must have an intellectual property clause, making sure that you own everything, not them. And confidentiality it's binding on employees, so it's an automatic implied term to every contract, but for a contractor, it's not. So there's slight difference between employee and contractors. And so you normally just put confidentiality, intellectual property clauses in both a contractor's agreement and an employment contract to make sure that everything is owned by you and is protected. And then setting out certain obligations. So if you're hiring someone that needs a driver's license, you say you must always maintain a driver's license. So that gives you a grounds to terminate them if they lose their license. Or they must be a registered lawyer. So if they have misconduct and lose their license as a lawyer, you can fire them immediately. So those are just some things to look out for. The other thing is a restraint of trade clause. A lot of times you probably had one in your employment contract in the past, and people say, oh, they're not worth the money they're written on. It's totally not true. Restraint of trade clauses are enforced every day in the Supreme Court. They are enforceable. There's a lot of room to negotiate it in court. There's a lot of room to look at the breadth of how enforceable is it. So you have these clauses called cascading clauses, and a restraint of trade clause generally means 3 elements. One is what is being restrained. So you're restraining someone from operating a competitive business. So one of your employees can't start a competitive business, but you need to define what a competitive business means, and it can't be too broad. If it's too broad, it's not going to be enforceable. So if you're Lawpath, you have a online legal platform that offers subscriptions to consumers, that's probably specific enough to be able to restrain myself, for instance, from opening up another business that does something similar. You also have to have a geographical location. And normally we do it in cascading scale. You can't have a competitive business worldwide. And if the court finds that worldwide is too broad, then it's all of Australia. And if all Australia is too broad, then the courts read that down to New South Wales only, and so on. And so if the court found that all of Australia is unenforceable, rather than striking the clause out completely, you say, well, no, okay, all around the world is too broad, but we'll just narrow it down to just Australia. And the court will say, okay, well, just Australia is too broad, and then we narrow it down to New South Wales. So if you've never seen a restraint of trade clause, the online platform offered by Lawpath, they have an employment contract called the employment contract bracket long form, and that has a non-solicitation clause, restraint of trade clause, and you can see how those clauses work. And then the other one is you generally your business continues to adapt, change, and that's great, but you can't necessarily adapt and change an employment contract. You're making an offer to someone to start business with you, to join your business. You can't then change the terms in which they came on, which means that normally if you're going to be making changes to your business, you're going to be making changes to your policies. So for instance, you might have an annual leave policy. You have to give us a minimum of 2 weeks notice before you intend to take annual leave, or 4 weeks notice, and we may reject it when acting reasonably. Or you might say that we have a Christmas shutdown period, so you have to take annual leave when we shut down. Or you might have sick leave policy that says you must give a medical certificate if you're away on a Friday or a Monday or a long weekend where it's a Friday or Monday afterwards, things like that. So if you go into the Lawpath platform and you go to the employee handbook, it has collated all the different policies that Lawpath has on its platform. And there's about 20 of them. And you can tick which policy you want to apply to your business, and then it collates it all and creates a handbook for you to then implement for all staff to follow. And so if you have a clause in your employment contract that says you must comply with all our policies and procedures as implemented from time to time, then you can change those policies from time to time and they're still bound by it. But you don't want to put your policies into the employment contract because you can't change the policies. And you don't want to put all your procedures into your employment contract because those are going to change over time. And you want to be able to change them without having to change the employment contract. Now, some people have what's called a modern award. So if you're in the manufacturing industry, you have the Manufacturing and Associated Industries Award. If you're in hospitality, you have the Hospitality Award. If you're, what else is there? In the construction industry, you have the Construction Industry Award. And essentially that has special rules for your industry. And a lot of people that I talk to might be in the construction industry. They say, okay, we're going to hire an employee. And I said, well, have you seen the modern award? And they're like, yep, I've looked at the at the payment guide, and so I know how much I need to pay my staff. And that payment guide isn't actually the award. The award is something completely different. The payment guide is just a schedule to that award. The actual award itself is a very long document that sets out penalty rates, not how much penalty rates are, but when they actually apply. Minimum rosters, for instance. So there's something called the miscellaneous award. We've had people that run tutoring businesses and they pay the tutor on a per hour basis every time there's a booking. And there's some case law that's come down that says, well, tutors fall under the miscellaneous award. And the miscellaneous award says you can't hire a casual employee for less than 3 hours or less than 2 hours per shift, which means that if you hired a tutor just to do a 30-minute session with a student virtually, you actually have to pay them a minimum of 2 hours. So that can compromise their entire business plan. So it's really important that you look at the modern award, and to find your modern award, you just Google find modern award Fair Work Australia or Fair Work Commission, and a website will come up where it asks you some questions and it tells you what award applies to your industry or business. Now, flexible working arrangements is a situation where you might be under a modern award. such as hospitality or something similar. And if you read that award, it says that people get time and a half or double time on Saturdays or Sundays, but it might be a case where you have some students and those students say, I want to work on weekends. I don't want to get double. I don't care about getting double pay on the weekends, but I don't want to be working during the week at all. And so you can come up with an arrangement where as long as it's better off for the employee, then you can make an arrangement to penalty rates, time for shifts, overtime hours, when they can take leave, when they can't take leave. You can actually effectively amend a modern award by going into a flexible working arrangement with a specific person. But the main thing is that the person or the employee has to be better off than based on that arrangement. So for instance, you have people that might have to drop off their children in the morning and then pick them up in the afternoon. And so but your office hours might be from 9 to 5:30. So you can enter into a flexible working arrangement that says, okay, well, you can start work at 10, you can leave work at 3, but you agree that you will do work after hours. Um, and that's fine as long as you enter into this flexible working arrangement. Now, it used to be only certain people were allowed to request it. Only certain employees were allowed to request a flexible working arrangement. But now they've changed the law that says that anyone can apply. And you saw it mostly from post-COVID, where people wanted to not return back to work. And in those circumstances, they asked for a flexible working arrangement that they don't have to come to work. And that goes back to the employment contract. I'll just mention quickly is if you hire a new employee and you just put in the employment contract, you get to work from home. It means that you can actually never get them to come back into your office if or when you get an office. So you don't want to say that. You want to say, in the employment contract, you have to work from our office, but you may be eligible to participate in our work from home policy. And then the work from home policy might say you can work from home for 5 days a week. But then in the future, you can amend that policy to 3 days a week or 2 days a week. So never put in the contract that they can work from home completely, because you might want to bring them back in 5 years from now, for instance. So flexible work arrangements, they're really important. They give everybody an opportunity to have some flexibility in their work, but an employer can reject it on reasonable grounds. So if you're in a sales team, you need to be part of the sales team because you're all working together. Salespeople generally work better together in a team. Then you might be able to reasonably refuse it if you can prove that the data shows that a salesperson working from home doesn't make as many phone calls as a salesperson that works from the office. So that's just a little bit about that. If you're looking up flexible work arrangements, the Fair Work Ombudsman has a lot of great templates. Obviously, Lawpath platform also does. But if you want to read up a little bit more about flexible work arrangements, just type in flexible working arrangements, Fair Work Ombudsman, or Fair Work Ombudsman templates, and they will come up and they'll explain the process, step-by-step guide on how to complete one. Also, just going back to that, flexible working arrangement can only be entered into after the employee becomes an employee. So you can't say, here's your employment contract, but we're going to vary it by this flexible working arrangement. You have to give them the employment contract and say, this is a flexible working arrangement that we agree to enter into after you sign the employment contract and after you actually commence working in our business. Now, they've also changed the law about fixed term contracts. So I'll give you a little bit of a spiel on unfair dismissals and general protections, just so that you know a little bit of what it is, how it works, who it applies to. So an unfair dismissal is where someone's being dismissed from their employment where it's been harsh, unreasonable, or unjust. And the people or the employees that are allowed to apply for an unfair dismissal, if the employee has less than 15 employees, that means that the employer is what's called a small business. If the employee works for a small business, the employee is only allowed to bring an unfair dismissal claim against that small business after they've been employed for 12 months. That means a small business has the right to consider whether an employee is being is going to be a good fit in the business for 12 months. So if you have an employee and you don't think that they're performing, you want to terminate them before that 12-month mark comes up. And so an employee who's been working for less than 12 months can't bring an unfair dismissal. An employee that makes more than the high income threshold, which is now $175,000 plus GST, cannot bring an unfair dismissal. A casual employee cannot bring an unfair dismissal, and someone that's on a fixed term contract cannot bring an unfair dismissal. Now, the problem with that is that a casual employee can convert into a part-time or permanent employee without you possibly even knowing. Because if you hire someone who's a casual and they work a regular and systematic pattern of work over a continuous period of time, they can be deemed a part-time employee. And there's a case called the Work Pack case where an employee was on a fixed term contract. So that means that they're on a fixed term contract. That means they can't bring an unfair dismissal. But they were on a fixed term contract for 1 year, and then it was renewed for another year, and then it was renewed for another year, and it was renewed 6 times for 6 years. And then the employer decided not to hire them again. And the employee brought the employer to the Fair Work Commission saying, well, I'm actually a permanent employee because I've been on a 1-year contract that's been renewed 6 times. And the court agreed. They said, even though fixed term contract employees can't apply for an unfair dismissal, they can if the court determines or the tribunal determines that they are actually a permanent or part-time employee. And in this case, the court found that they were a permanent employee because they had a reasonable expectation for future work, which meant that their fixed term contract that kept on renewing, they had a reasonable expectation that it would just continue to be renewed. And so in those circumstances, the employee was found to be a permanent employee. Now, they've changed the law because of this case and a couple other cases, and that now says that if you hire a fixed term employee for a period of 2 years or more, they automatically become permanent. So that's to prevent employers from putting people on a 1-year contract and then to try to say, well, you can't bring an unfair dismissal claim. So they've limited it to no more than 2 years. So that's just something to know, that just because they enter into a fixed term contract doesn't mean that they can't bring an unfair dismissal. Now, unfair dismissal has its limitations for employees, like you have to work a minimum employment period. If you aren't a small business employer, so if you're an employer that has 15 or more employees, that 12-month period is reduced down to 6 months. So that means an employee only has to work 6 months to be able to bring an unfair dismissal. But an unfair dismissal doesn't apply to casual employees, fixed term contracts, people in the high income threshold, unless it's found that they actually are permanent. So that's just something to note. Now, just because they can't bring an unfair dismissal, they can bring something called a general protection. And a general protection is under section 340 and 341 of the Fair Work Act. And it says that an employee who has a workplace right, who exercises that workplace right, and as a result of exercising the workplace right, their adverse action has been taken. So put that in practice. Someone makes a complaint being bullied and harassed, and as a result of them making that complaint about being bullied, you terminate them. That is a general protection, because under the occupational health and safety legislation, they have a workplace right not to be bullied. They've exercised that right by making the complaint, and you took adverse action by terminating their employment. And there is any employee, any kind of employee can bring a general protection. So just because your employee might not have an unfair dismissal claim, they still might have a general protection claim or an unlawful termination. Like if someone takes sick leave and then you terminate them from their employment for taking sick leave, well, there's 2 different areas that could bring. One is general protection. They had a workplace right to sick leave. You've terminated them after they took it. Or an unlawful is that you've unlawfully terminated them because they exercised their legal right, and you've unlawfully terminated them for exercising their right. Now, one thing else is that they passed new legislation that the terms of the employment contracts are no longer secret in terms of the payment. So that is to reduce the gender gap. So if someone is paid, you can't have a clause that says you must not disclose your pay to other staff, and that's so that other staff can talk amongst themselves about what they are getting paid. And there's no right for the employer to claim secrecy over that. On the 1st of July, the high income threshold increased. Every year on the 1st of July, it increased, which means that if you are paying someone $174,000, you might want to consider putting their employment up to $176,000, so that that would protect you from an unfair dismissal. Now, if we look at drafting an employment contract, one of the ones is being fair, and I'll talk about that as well. You know, where I was talking about notice period, you can't put a clause in that says the employee must give 4 weeks notice if they're going to resign, but we only have to give 1 week's notice to terminate them. That's not an unfair, that's an unfair contract term, and it won't be binding. So you need to normally do a reciprocal one. Whatever they have to give, you have to give. Now, you can also put other clauses saying, all right, well, I want them to give 4 weeks notice before they leave. And mainly the 4 weeks notice is for handover process. But you can also put what's called a garden leave provision that says once they do give notice, they must cease communicating with your clients. They must cease communicating with all their staff. You can direct them to work from home. And that's to give you an opportunity to bring someone else in to take over their responsibilities during the handover. And it prevents the employee from telling other suppliers or customers that they're going somewhere and start colluding with them about going to a new business. So you can put them on garden leave. If you don't know exactly what garden leave is, you can Google it. Now, national employment standards, all employees have these rights. This is the minimum, and you don't necessarily need to put in an employment contract all of these items. But generally speaking, an employee only has to work 38 hours a week. If they're on a salaried position and they're getting paid well above the modern award or the Australian wage minimum wages, then you might be able to require an employee to work extra hours reasonably to fulfill their responsibilities. But a right to flexible work arrangements, a right to convert from a casual to a permanent, parental leave, annual leave, sick leave, compassion leave, carers leave. Anyway, you can read all those, but those are all the minimum standards for those who are not on a modern award or just all employees in Australia. Now, when you want to look at what to put into your employment contract, again, it really does depend on what industry you're in, the seniority of the person, whether that person is likely to move up into a more senior role, how many staff you have, what your turnover is. So these are some of the things to consider when you're going to draft your employment contract. Nowadays, most people just use a template. Lawpath has various different templates. So if you are going to use the Lawpath platform, make sure you use the right template. So we have casual, part-time, full-time, and long form and fixed. And if you are going to use the casual employment or agreement or the part-time one, it doesn't necessarily include the comprehensive clauses that the full-term long-form contract has, such as non-solicitation, restraint to trade, possibly the intellectual property and confidential information clauses as well. So if you do use one of Lawpath's casual employment contracts or part-time ones, make sure you have a look at the long-form employment contract and possibly bring across some of those clauses that might be important to your business. Now, they've also changed the law in terms of sexual harassment and workplace bullying. There's a positive obligation now under the occupational health and safety legislation that it's not that you must minimize sexual misconduct, you must prevent. And that means you actually do have to have a policy. So you actually have to induct your employees with a sexual harassment, workplace bullying policy that and get them to sign off on that policy, showing that you've complied with your OH&S law by implementing a policy to prevent that from actually happening. And if you don't, then you can be liable for the actions of your employee. Other policies to just think of is IT use policy. So You can possibly surveil people in terms of including, if everything's stored on your server, you can see if they're downloading documents onto their desktop, things like that. So social media policy, it's not uncommon where hairdressers and people that use an Instagram account, you might want to have some measures to protect that. We get a lot of complaints from hairdressers and beauty salons where their employees have taken a lot of pictures while they're working, and then they've gone started up their own business and taken all those pictures that they took and used them on their new Instagram account. And that if you want to protect your business from something like that, you want to have a clause in your employment contract saying that you own all the intellectual property, and you also want to have that intellectual property includes any photographs or videos taken during the performance of their roles and responsibilities so that you can claim copyright ownership over those photos. Because otherwise, the person that takes the photo under the Copyright Act owns the photo. So that's just something to note as well. Confidentiality agreements, non-compete agreements, these are normally embedded into your employment contract. But if you have a contractor and you don't have those in your contractor's agreement, it's important that you get one so that you have your confidentiality protected. Social media policy, I'll just explain a case from 1937. Long time ago, there was a golf course. That golf course kept on having someone post a sign in the golf course saying, "Don't golf with Byrne. Byrne's no fun to golf with. He's not a great person." And every time Byrne would show up, he would complain and say to the golf course, "Take that down. Don't let people post that." And every time he showed up, that post was still there. And so eventually he just sued the golf course on grounds that the golf course allowed them or was deemed the publisher by allowing people to post it and them not monitoring it. They then applied that case to a Facebook case where there was a Facebook page where people were publicly publishing things on a company's Facebook page. Someone wrote to the company and said, "Take that down." They refused to do so, and they were found to be deemed the publisher and liable for defamation. So if you have Instagram accounts, Facebook accounts, any kind of social media, you want to make sure that you're monitoring it, make sure that you take down anything that might be defamatory. And if someone asks you to take it down, you'll be deemed the publisher if you don't. As long as that defamatory remark is actually not true and defamatory. IT uses policy, there's been interesting cases you might have seen in the news where someone was dismissed from their employment. They then went and filed an unfair dismissal claim, and it was found that that employee had been monitored, and it showed that she only did 12 keystrokes on her computer a day, which was basically her username to log into her desktop to turn it on. And the Fair Work Commission said that they were allowed to use the monitoring software and that the employee was terminated because they weren't actually doing anything other than logging into their computer and nothing more. Going back to OH&S, you have an obligation to make sure that your employee is safe in their workplace. That includes working from home. So if you don't have a work from home policy, you should get one. If you don't have a work from home checklist, you should get one. Lawpath has the work from home policy. If you're ever needing help with occupational health and safety policies, procedures, guides, checklists, things like that, Safe Work Victoria has really good templates. Lawpath can't cover everything, and Safe Work Victoria has a lot of free templates. And the law in Victoria is very similar to most of the other laws because most of the states have implemented a model law, except for Western Australia, that's all very similar. So Queensland, New South Wales, and Victoria. So if you use those templates from WorkSafe Victoria, they're going to be fairly close to the requirements that you need for your other states. That's just a little bit of a tip. Now, looking at so on the 1st of July, they change all the modern awards. They also change superannuation entitlements. So the minimum wage now for any employee is $915 a week. Most people are paid much more than that, but it's $24.10 per hour. Each of the awards have also changed on the 1st of July. So if you haven't updated your payroll system, do it now. Also, superannuation entitlements has increased from 11% to 11.5%, and it's going up to 12%, and then it will stop there next July. Overtime laws, you are allowed to allow people to, or you are allowed to have your employees work overtime, but you got to look at the risk and to their health and safety. You can't have people working 100-hour weeks when they're only being paid 38 hours a week. If they're on a modern award, you got to pay penalty rates, overtime rates, unless you have a flexible work arrangement as discussed before. And these are all your these are all your leave laws, which automatically apply. So I've seen where people have been given notice that they have to apply to and go to jury duty for 12 weeks, and the employers terminated them as a result of that. You must allow your employee to take leave. It's generally unpaid leave, but the government actually pays the employee for the jury duty. And that's it. So what I'll do is I'll pass over to Connor. You guys drop in any questions, whether it deals with employment or anything, I'm happy to answer. So drop in anything into the Q&A, and I'll be back in about 5 minutes. Thank you.
Easy. Thanks, Damin. Yeah, just to reiterate that, guys, if you do have any questions on employment or anything in relation to the slides or otherwise, please drop them in now to that Q&A chat. There's only 3 questions there in the moment, so look, if it's actually, we'll probably have time. If you do have questions for something else, maybe unrelated, but it is commercial and legal, if we have time for it, I'm sure Damin can address it as well. Something I actually mentioned on the webinar about 2 weeks ago was actually around the workplace policies, and I think that's something that always gets really slept on. I had a conversation with someone who uses the Lawpath, uses our essentials plan. She's a compliance and business consultant, and she was really stressing to me that small business owners not having the right up-to-date employment contracts or not having the right workplace policies is a real red flag with her, something that really gets slept on, and what can really wipe out small businesses if you ever do find yourself in a bit of hot water with potentially a disgruntled employee. The legal fees and court alone can really take people out. So don't want to put the fear of God into people too much, but we have have a lot of workplace policies for you there. We have the employee handbook there for you guys. So do check it out if you need to update your contracts or do need to get something in place. I'm quite conscious that a few people are actually audio subscribers, but just to give a bit of a rundown very quickly on obviously how Lawpath can help, especially around the employment side. Obviously, we supply your business with unlimited legal documentation. Those include your employment contracts, those workplace policies, and you can pretty much draft these within 5 to 20 minutes. They're 99% complete. You just have to follow the contract builder to each key provision and clause. And we also actually have a series of workflows. So these are 12 tasks, but 3 of them are actually sort of employment related, around dismissing an employee, hiring an employee, hiring a contractor. And these workflows are basically designed as if you were hearing it kind of from the horse's mouth. They're a good kind of middle ground if you don't have access to a lawyer, but want to kind of hear what the step-by-step process would be if you were receiving that advice. I can see as well from the poll, most people are registered as companies, which is great. Lots of legal and tax benefits from doing so. Very few people actually registered as a trust. Depending where you're at in your business journey, there might be something you want to actually look into for some extra benefits there, and something we can help you with. Or even, yeah, you've got that company, but maybe you want to look at this time of year around restructuring the company setup. That's something we find really happens around that July, August time for a lot of existing companies. And it's also the sort of the hottest time of year we get new businesses setting up as well. And a few people had concerns or questions around tax consideration, around GST registration, tax deductions, tax compliance. That's a really hot topic with our existing subscribers on the accounting advice plan, especially around this time of year with the annual tax returns due. And actually, probably Amazon is probably the best example of a business, if you do Google it, what their expenses are compared to what their net profit is. They do get quite a lot in tax reductions there. So we have on here also our legal advice plan. So this is our most popular subscription. We do also have accounting plans available as well, and these are much more economically viable options for startups and for businesses. So we offer a subscription model with year-round support where you can get unlimited consultations and on-call contract reviews for just $537 every 3 months. So perfect for a small business. A lot of senior lawyers, for example, will bill $500 to $700 just for that hour's consultation. So a much better option there. You do also have a live chat connected to our legal team. Also, you can book legal consultations with our internal lawyers. You can see in the link provided within the same day or next working day. And I've included a link there as well, as I said at the start, where you can see some of the hot topics. A lot of these center around business structuring, business purchase and sell, finding out what contracts you actually need for your business, for clients, for partners, suppliers, and employees. Intellectual property and trademarking we cover, debt recovery, ESOP, and commercial property law, but to name a few. If anyone would actually like to discuss sort of the full breadth of services we cover at Lawpath, please just type yes in the chat, and someone can reach out to you to discuss further. They can even run a demo of the platform for you so you can see it from the perspective of our current subscribers. But you can actually also, if you prefer, just send me an email. I'll list my email address in the chat. If you're just looking for documents, obviously the documents are fully customizable, and you've also included some AI tools there, which uses different multiple language models. You can ask it legal questions, it can draft additional clauses for your document, and it can review your document and provide further key insights around. That includes documents you might use on the platform, but also anything external you might upload as well. So if you do have an employment agreement that you've been using, you can upload it onto Lawpath and the AI will review it and you can ask it questions around the document. And it also has a simplify mode, which I use quite a bit. If you're like me with no formal legal background, you may be looking at specific bits of legal jargon or clauses within the contract. You can quickly highlight it and it will re-explain it in layman's terms. And finally, so we've got an accounting advice plan, and we've actually now split, but you can bundle them together, which you'll see on the next slide, a tax compliance component as well. And that's probably our most comprehensive package or bundle. It works in the same function as the legal side, so you have unlimited consultations with our senior chartered accountants. They cover a lot of advice around tax minimization, tax concessions, also business structuring advice, trust advice, a whole host of different reporting advice, software advice, bookkeeping, superannuation, the whole lot. And if you are looking to fulfill your tax obligations for the business, we do have that standalone tax compliance plan. They'll do all that hands-on work, so your VAT lodgements, tax lodgements, and financial statements. And you do as well get a special fiscal year consultation to a deeper dive and analysis of your business's spending and revenue. But for all attendees today, we do actually have 25% off on our legal plan. So you will have immediate access to our templates. You can be able to book a discovery call with one of our lawyers as soon as tomorrow. And this is basically an opportunity to outline your business with any short and long-term goals, discuss any pressing legal matter that you're sort of concerned with. But really it's the lawyer's job to kind of poke and prod and expose any legal gaps within your business you're not aware of, as you don't know what you don't know. So the code for that is the webinar LAP24. But we actually also have this on our bundles as well. So we've revamped the way we basically help new businesses, but also our current subscribers. There was some limitations there previously for how you can get all the services, but you can now actually combine different services together, basically giving you the best fit for your business. So if you are an existing subscriber and you've been looking to potentially upgrade your plan, or you actually have a subscription where you would like to maybe keep certain aspects of it, but take other parts out, the bundles are now a great option for you to do exactly that. All right, thanks for everyone attending. We'll see you on the next one. Cheers.